Good morning to everyone. My name is Brooke Guven from the Columbia Center on Sustainable Investment. Well, good morning here, I guess. Good morning, afternoon, or evening. Thank you all for joining. We hope that you and your families are healthy and safe during this challenging time. Before we get started, I just want to provide a quick run of show. So all participants should be muted with video off. So if you could please not change those settings until instructed to do so during the Q&A, we would appreciate it. We'll have 40 to 45 minutes of presentation with the balance of the 60 minutes allotted to a Q&A. If you have a question, you can either type it into the chat function or you can raise your hand during the Q&A. We will then unmute you. You can ask your question and we will answer it. The webinar is being recorded and it will be made available on our website, but we won't include the Q&A in the publicly available recording. So I'll now turn it over to Ralph to kick things off. Ralph, you just need to unmute yourself.
Sorry. Thank you, Brooke, and good morning, afternoon, or evening to everyone. Very glad that you're able to join this webinar, particularly in these tumultuous time. Like Brooke, I hope that you are all healthy and safe. Allow me to introduce myself. My name is Ralph van der Beek. I'm the Deputy Head for Trade and Investment Policy at the Ministry of Foreign Affairs of the Netherlands. And I'm very happy to join Brooke, legal researcher at the Columbia Center on Sustainable Investment, and Lise Johnson, Head of Investment Law and Policy at that same center as co-organizers, co-host of this webinar. The theme of today's webinar is International Investment Law Assistance Mechanisms, Issues, Evidence, Lessons Learned, and Proposed Solutions. And we think that assistance mechanisms in investment proceedings are a timely issue. There have been several bilateral and multilateral initiatives launched to modernize the system for the settlement of international disputes between investors and states, including within the framework of Arbitral. Within these discussions on the modernization of the international investment agreement system, several stakeholders have expressed their concern that not all parties in investment procedures are equipped to adequately defend themselves. There are, of course, different reasons for this. Think, for example, the high cost or technical nature of the proceedings. And of course, sometimes one disputing party has superior experience with procedures under international investment agreements than the other. To find out more about the underlying issues, concerns, and the lessons learned, as well as on proposed solutions, the Ministry of Foreign Affairs of the Netherlands, together with Thailand and Peru, and I want to particularly thank our colleagues from Thailand and Peru for their support and joining us in commissioning this study. We commissioned a scoping study on securing adequate legal defense in international investment agreement procedures. And Brooke and Lise, who prepared this study, will further elaborate on the main findings later. But let me begin with explaining our rationale behind this study. As research has proven, foreign direct investment plays an important role in financing sustainable development. FDI secures means for economic activity and fosters growth and employment. Focusing specifically on developing countries, the need for investments in these countries alone is estimated at a range from 3.3 trillion to 4.5 trillion US dollars to achieve the SDGs. The financing for sustainable development is available as gross world product and global gross private sector financial assets are estimated at over 80 trillion and $200 trillion respectively, according to the World Bank. However, available finance is not channeled towards sustainable development at the scale and speed required to achieve both the SDGs and the goals of the Paris Agreement. In fact, at current levels of investments in sustainable development related sectors, developing countries face an annual gap of 2.5 to 3 trillion US dollars, according to UNCTAD. Besides public efforts, therefore, the private sector is vital in reaching the required scale of investment. And attracting FDI is therefore pivotal for all countries in their efforts to spur growth and development. There are many factors, of course, that play a role in the flows of FDI, and one of them relates to good regulatory frameworks. And here, investment agreements as part of that regulatory framework can play an important role in attracting sustainable private investments. So we recognize both the importance of FDI in achieving the SDGs, as well as the role that investment agreements can play to do so. But at the same time, we acknowledge that states, particularly developing countries and least developed countries, and other parties, such as small and medium-sized enterprises, can and must effectively participate and benefit from the system in order to do so. So the scoping study provides a solid basis for discussions on the desirability and feasibility of creating or expanding an assistance mechanism. And we particularly commend the Columbia Center for taking into account the lessons learned from regional initiatives on the establishment of such assistance mechanisms that have already taken place, which have been initiated but have not been concluded. To wrap up, we are very thankful for the excellent work by the Columbia Center on Sustainable Investment, and I'm very much looking forward to a fruitful discussion with you in the upcoming hour. Please also be aware that we will be hosting a lunch event during the upcoming UNCITRAL meeting, of course, once this will take place, to further discuss this topic. And of course, we will send you invitations with further information once dates are confirmed, and we all hope that will be sooner rather than later. But thank you very much, and again, looking forward to a fruitful discussion.
Thanks, Ralph. Indeed, sooner rather than later. Once again, I'm Brooke from the Columbia Center on Sustainable Investment. CCSI is a joint center of Columbia Law School and the Earth Institute at Columbia University in New York City. And our mission is to develop practical approaches for governments, investors, communities, and other stakeholders to maximize the benefits of international investment for sustainable development purposes. So now I will put up some slides. Yep, perfect. Okay, so as Ralph noted, CCSI was commissioned by the Ministry of Foreign Affairs of the Netherlands to conduct a scoping study assessing the hurdles experienced in ensuring adequate legal representation in proceedings under international investment agreements. And this presentation is intended to briefly highlight the study and our findings. Next slide, please. The scoping study is available on our website. As Ralph mentioned, it's timely for various reasons, not least of which is that the matter of an International Investment Law Advisory Center is also now an element of ISDS reform discussions taking place within UNCITRAL's Working Group 3 on ISDS reform. CCSI has been participating as an observer organization in those discussions, and we hope that this study will usefully assist policymakers in that context. And I should note, in our study, we actually use the term assistance mechanism rather than advisory center to indicate that a variety of models may be developed and that each may respond to different kinds of challenges and advance different kinds of objectives. And I would also like to emphasize that the study does not advocate for a specific model of assistance mechanism. Rather, we set forth issues, evidence, lessons learned, and a variety of potential solutions that could be developed to respond to specific capacity challenges. Next slide, please. So our approach in the scoping study was to conduct interviews with government officials of all World Bank Group economic development levels, with individuals who have experience working for existing or attempted assistance mechanisms, individuals who have experience working with arbitral institutions, academics who have written on or advised states with respect to international investment law, private practitioners, representatives of NGOs, and representatives of private sector foreign investors. Interviewees were asked to share their experience and ideas relating to capacity challenges and how an assistance mechanism could or should address them. And the interview protocol that we used is included as an annex to our scoping study. Next slide, please. So the issues that are set forth in the scoping study include an overview of capacity challenges that were identified during our consultations, of previous attempts to establish investment law advisory centers, models of assistance mechanisms that may be considered for an investment law assistance mechanism, cross-cutting issues that emerged that would be important for policymakers to consider regardless of the form that an eventual assistance mechanism may take, And also, and finally, the particular issues faced by investors and considerations surrounding investors as beneficiaries of assistance mechanism services. So the presentation today is roughly going to follow that order, and obviously out of necessity will be rather brief, but I would direct everyone to the scoping study itself for much greater detail on the issues that I'll now discuss. Next slide, please. So I'll start by overviewing the various capacity challenges relating to engagement in the investment treaty and ISDS system that were articulated to CCSI during our consultations. So notably, our consultations revealed that the concerns are much more fundamental than only financial costs of participation in the system, although that concern is also significant. Interviewees relayed challenges ranging from effectively formulating and implementing investment policy at the domestic level through and including effective engagement in formal ISDS proceedings. Some challenges that we described were shared by many states and others differed. And importantly, many states expressed different priorities in addressing these challenges. So some priorities were relative, based on resource constraints, but others were more fundamental opinions about what role an assistance mechanism should or should not take. For example, whether it should be providing direct legal assistance or direct legal representation, or whether it should be permitting investors to use its services or not. Next slide, please. So based on the wide range of challenges articulated to CCSI, the study looks at capacity challenges experienced by states in various different phases of investment law, both in the pre-dispute context as well as during dispute management. And it considers whether and to what extent existing mechanisms are already filling certain capacity gaps in these areas. And it includes a discussion of what assistance is already available to states and to some extent to investors. So the thematic areas of investment law that the study considers in depth, which are those on the screen, I'll now discuss each briefly in turn. So next slide, please. So starting with an overview of capacity challenges in the area of investment policymaking. So some of the select capacity challenges that we identify and discuss in the scoping study include challenges that states experience in effectively engaging in the multitude of fora in which investment policy issues are being discussed and advanced. So for example, UNCTAD, the OECD, UNCITRAL, the Financing for Development Agenda, investment facilitation. And the hurdles that are experienced here are not limited only to the financial and human resource expenditures, but also on the formation of cross-government strategies and communication channels at the domestic level. And there are various primarily international organizations with a mandate who are providing valuable services in this area. So UNCTAD, the OECD, and the World Bank Group. Next slide, please. So moving on to treaty negotiations. The negotiation of treaties can place particular and time-sensitive demands on governments. For example, in assessing and understanding the particular domestic impact of certain proposed provisions. Various states described capacity challenges in cross-governmental communication and ensuring a consistent approach to policymaking. And then there are also systemic hurdles, such as the negotiating strength of states and in actually ensuring that a state's objectives are reflected in a negotiated instrument. And there are some primarily ad hoc support available to states in this area. And the study also goes into examples from other areas of law to show how more organized support may be given to states in this area. So for example, under the UNFCCC, the European Capacity Building Initiative provides support in this vein. Next slide, please. So with respect to the domestic implementation of international investment agreements and dispute prevention, many interviewees articulated challenges in this area. And they were also quite interested in learning more information about how to manage these challenges. The domestic implementation of treaty obligations can be a very state-specific and nuanced and thus resource-intensive task. And notably, these challenges may be greater in decentralized states where state, local, or provincial authorities have significant governance capacity and decision-making power. So there are some existing providers here. There's UNCTAD. The World Bank is piloting its systemic investor response mechanism in a rather large handful of states. And various states are implementing other forms of ombuds offices or similar management systems to try to address investor issues before they turn into ISDS claims. Importantly here, some disputes, however, cannot nor should easily be prevented. For example, disputes that may arise out of judicial processes. But nonetheless, this was an area of great interest for many governments. So next slide. So this slide is really here to show an example of how these issues may play out. So as treaties become more complex, capacity challenges may also intensify. And this may be the case with, for example, understanding the implications of liberalization provisions and restrictions on performance requirements for domestic, economic, social, and environmental policies in the short, medium, or long term. And we can see here, for instance, that Canada is relatively more protective of its policy space than its treaty counterparties in Africa and Asia. And this may be due to disparate capacities in understanding the implications of these provisions or disparate negotiating capacities. And regardless of the cause, this disparate approach to carve-outs will also likely result in disparate burdens in terms of domestic implementation. Next slide, please. With respect to ongoing treaty management, when treaties are signed, it does not signal the end of a state's engagement, but really just the beginning. And states reported capacity challenges in ensuring consistency and coherence in pleadings, in submitting non-disputing state party briefs, in engaging in joint treaty interpretations, and consultations revealed significant scope for support that could be provided to states in these areas. Next slide. So this graph shows one example of treaty management. It reflects data on non-disputing state party submissions. So here you can see that in the bilateral treaty context, non-disputing state party submissions are extremely rare. And this is actually also the case in a large handful of multilateral treaties as well. So this indicates that should governments wish to try and rein in certain expansive interpretations of their treaties, there are currently unseized opportunities for them to do so. And it may be worth further exploration and understanding why governments are not or cannot engage in this context, and what may be done to assist them in managing the appreciation of their treaty intent through this kind of engagement. Notably, in the bilateral context, capital importing states may rarely be non-disputing state parties, however. Okay, next slide. So moving on to the dispute phase. With respect to case staffing and procurement of outside counsel, this is a obviously massive topic, and it's considered in fairly great depth in the study. But essentially, the frequency of cases against a state is perhaps one of the most, if not the most relevant questions for understanding how states wish to staff defensive claims. And there are generally three models that states use to staff their defense. One is a hybrid model, and this is the most common, so using a mix of outside counsel and in-house counsel. Next would be an exclusively in-house counsel model. And then less common would be an exclusively outside counsel model. So in our consultations, some states did express a desire to move to an in-house model. Many states plan to retain a hybrid model, but did express an interest in gaining greater control over the management of their claim and over outside counsel. And they also wished to understand and have a greater appreciation for how to bring certain activities more in-house than they currently are. With respect to actually procuring outside counsel and the cost that states are spending on doing so, these appear to be driven by a variety of factors. So it was noted that some states feel compelled to hire the best outside counsel simply because the state and the officials themselves will need to justify that choice to many different stakeholders. And some states may be willing to forego other spending priorities in order to hire such counsel. On the other hand, some states cannot or choose not to allocate those kind of funds. One study we discuss in the scoping study indicates that lower income states may be more willing to settle claims. And the systemic impacts of this finding would be extremely relevant when considering a role for an assistance mechanism and how it may assist states in appreciating claims against them. One thing that I want to highlight that was raised by a few states was the idea of a hotline. So a go-to trusted place upon which states could call to get immediate answers to pressing questions. And this was spanned the spectrum of policy implementation, dispute prevention, as well as the actual management of disputes. So this possibility was raised by states both that wish to manage claims internally, should they have pressing questions that they don't have the answer to, but also with respect to states that would hire outside counsel but may have questions before such counsel is procured. Next slide, please. The slide on anticipating and potentially resolving disputes at an early phase is very similar to that already discussed here, but was intended to focus more on the role of a cooling off period and the capacity challenges that states have in effectively managing this time. Internal delays, which may be caused due to the lack of efficient command or communication channels, can have long-term impacts on the management and success of a claim. Next slide, please. With respect to appointing arbitrators, asymmetries of information about potential arbitrators can create hurdles for certain states, and there is scope to have more information publicly available or available on a no-cost basis. Okay, so dealing with uncertainty and ambiguity in ISDS claims, there's a variety of ways to manage these issues, and they include, among other steps, joint interpretations of existing agreements or clarifying language in new agreements. Some states experience challenges in entering into joint interpretations, and more work may need to be done to understand why joint interpretations are infrequently used, to the extent states wish to use them. Okay, next slide, please. So the scoping study details previous attempts to use an advisory, to establish an advisory center. So it considers a joint effort by UNCTAD, the Inter-American Development Bank, the Organization of American States, and the Valle Columbia Center on Sustainable International Investment, which is a predecessor to CCSI. This effort started around 2006 and ended in 2010. Significant progress was made, but it was ultimately unsuccessful. The study also considers a UNISOR effort, as well as a Australia, New Zealand, ASEAN effort in 2012, which advanced less than those above. Based on research and interviews with those who were involved in these efforts, a key takeaway is that one cannot underestimate large policy differences. So for example, the scope of services of a mechanism or how it will be financed, but also seemingly small decisions, such as where a mechanism will be located. Because disagreements over these large or small issues can halt any effort, even when it may be very close to the finish line. Next slide. So So I'll move on to overviewing potential models that an assistance mechanism may take, each of which are discussed in much greater detail using examples in the scoping study. Next slide. One model that we analyze is an institutionalized multi-service support model, which would include legal representation. So such a model could include services such as capacity building, negotiation support, policy advice, legal opinions, or defense in actual proceedings. And examples of this model that are considered are the Advisory Center on WTO law, which we're going to discuss in more depth in a moment in this webinar, the African Legal Support Facility, or IDLO's Investment Support Program for LDCs. Next slide, please. A second model is that of institutionalized multi-service support, but not including legal representation. So one that would offer services including capacity building, negotiation support, or policy advice. And various kinds of organizations are currently engaged in this kind of support. So international organizations, arbitration centers, academic institutions, and nonprofit organizations. Next slide. A third model is financial or in-kind support. So trust funds, third-party funding, and contingent representation by law firms are some ways in which we talk about in the study. So for example, with respect to trust funds, the Permanent Court of Arbitration has a trust fund that can be used by states in claims before the PCA. And interestingly, this trust fund model is something that's used much more prevalently in other areas of international law, such as criminal or human rights law. Next slide. There are a few other models that we discuss in the scoping study. So these include pro bono ad hoc legal support, intergovernmental knowledge sharing hubs, so opportunities for states to share experiences and lessons learned in various areas, discrete capacity building networks, so courses or various kinds of training, and then finally a legal assistance or resource clearinghouse, so a place where governments could go simply to understand and appreciate the range of existing services that are already available to them. Next slide. So I'll now quickly overview the cross-cutting issues that are applicable to all models of assistance mechanisms before Lisa goes into some of these in a bit greater depth in the context of the WTO Advisory Center. So the cross-cutting issues: quality, reliability, reputation, and trust was stated to be the key issue during our consultations. Interviewees stressed that there must be an alignment of interest between any assistance mechanism and the state, and this would be including but not limited to financial interest. With respect to funding and scope of services, it's clear that the depth of countries that can access services and the breadth of services that can be offered will be highly dependent on the funding of the assistance mechanism itself. With respect to costs of support and who bears them, a few models are explored in the study, including one where a service provider pays, so something akin to a pro bono model, where a donor pays, so a development agency could finance a mechanism, or a user pays, either market or reduced fees based on development level or other factors. And these models can be used in combination depending on who the beneficiaries of the mechanism and its services are. So, stakeholder conflicts of interest and tensions. There are different relationships between donors, support providers, client governments, private or government-owned investors, and other stakeholders that are going to be more or less prevalent depending on the range of services that are provided by an assistance mechanism. And in some cases, these relationships may become serious and worthy of working around or taking account of. So the question of who should benefit from an assistance mechanism services is a critical one, and one that is again closely tied to identified capacity concerns and with the mechanism's objectives. So for example, treaty negotiators, officials who defend claims, other government officials who are responsible for domestic implementation, SMEs or other stakeholders, such as civil society, could be among those who potentially benefit. The location, staffing, remuneration of a mechanism and its employees elicited many differences of opinion. Answers to these questions have also been an issue in previous attempts to create an advisory center. And the ways in which one approaches these issues also depends on the role of the mechanism. For example, if a mechanism is more involved in legal representation, it may make sense to place it in a commercial hub, such as Paris or Washington, DC. But the mechanism then becomes very far removed from the client governments that it's servicing. So there were suggestions for a mechanism that could have multiple locations with obvious cost implications. And with respect to staff, there was a focus not only on diversity of staff, but also on what staff would be appropriate. And that also, again, depends on the mechanism's role. For example, depending on the role of the mechanism and its objectives, individuals with development policy backgrounds should or potentially could be more embedded with other teams of legal advisors. The long-term sustainability and a government's ability to continuously and certainly rely on the services of a mechanism was considered to be a key issue. The degree of institutionalization of a mechanism was also raised. For example, whether more informal networks should be given support for expansion rather than creating an entirely new mechanism from scratch. The politics surrounding the creation or expansion of an assistance mechanism are also explored. And this has a few facets. For example, how and whether the mechanism should be tied to any particular form of reform. And then also, with respect to previous efforts to create an advisory center, it was reported that, or reportedly, law firms may not have been fully supportive. It was, however, noted in our consultations that law firms are not monolithic and that outside of a small handful of firms, most firms make money off of claimant work. So it's unclear what the role of law firms and the support of law firms would be. And then finally, policymakers should bear in mind how the challenges that an assistance mechanism is intended to address interact with other reform efforts. For example, efforts to reduce costs or limit claims through, for example, reform of reflective loss, state-to-state filters, or domestic exhaustion requirements may go some way to addressing some of the issues that could be the subject of an assistance mechanism. So I will now turn it over to Lisa to discuss the ACWL in a bit more detail.
Great. Thanks, Brooke. Good evening, afternoon, morning, depending on where you are. As Brooke noted, I'm going to provide some information on the ACWL, the Advisory Center on the WTO law, as that is often seen as a model that could be incorporated in an ISDS context. And I'm also going to use that as an example to further elaborate on some of the cross-cutting issues that Brooke had mentioned. So overall, the ACWL is regarded as a well-trusted mechanism to help developing countries effectively participate in the WTO system. Based on interviews and desk research that we did, there seems to be a high degree of trust and respect for the ACWL, the role it plays, and the services that it offers. Next slide, please. So the ACWL, sorry, these slides, the images might be difficult to see, but they're all in the study. These charts are. So the ACWL provides support in a number of ways. It provides reduced cost direct assistance to claimants and respondents in WTO dispute proceedings, provision of private counsel at preset rates in some contexts. It provides free training. It provides free legal opinions on a range of issues that may relate to negotiations, to implementation, and to claims. It offers secondments, and it has a fund for use of expert witnesses. So the table on this slide, which is in the report again, and is also from an ACWL annual report, helps illustrate kind of the quantity and breakdown of activities. So for instance, in 2018, the ACWL received 5 new requests for assistance and was handling 17 disputes at various phases. It provided 237 legal opinions, and it provided 39 certificates of training. Next slide, please. So focusing specifically on the dispute settlement role, the ACWL charges member users and LDCs, ACWL charges member users, yes, and LDCs a small fee. The fee is set at an hourly rate, and a maximum fee cap per phase of the proceeding is also set. The table shows the fee for panel proceedings. So each country category, country A, B, or C, is based on a formula that's determined by the country's economic profile. So in the study, we had outlined these 3 basic and often overlapping models of funding: a service provider funded support model, user funded support, and third-party funded support. As you can see here, ACWL litigation support is partly a user fee model. There was also a third-party funder and service provider funder model. The fees for litigation that are paid by the users are also subsidized by payments made by donor countries and member countries, as well as returns from the ACWL's endowment. So in contrast, there are no fees that are charged for ACWL legal opinions and trainings. Let's go to the next slide, please. So one important consideration is whether handling WTO disputes is comparable to handling ISDS disputes. There are some differences that are often noted. One is that WTO disputes are state to state. Another is that states in the WTO can be both claimants and respondents. But another important question that had been flagged to us and that we dug into a bit further is whether WTO disputes and ISDS disputes are comparable in terms of the amount and nature of resources required. Now, it seems like that there are some fundamental differences between these 2 systems. So in particular, the ACWL estimates that each case will require a set number of hours and then sets a corresponding maximum charge to users. The estimate for the number of person hours required for a WTO panel proceeding was in 2018, 444 hours. So let's compare that now then to ISDS proceedings. It's actually difficult to gather data on hours required, as the public portions of cost submissions generally don't provide the number of attorney hours worked. But we did locate the data in a couple of filings, which are listed here. So note that the hours for 2 relatively recent ISDS disputes, each filed against Canada, were roughly 20,000 hours. So this also appears somewhat representative as the overall legal fees expended seem to track, maybe potentially at the low end, the average fees expended by respondents in ISDS cases. So it may be that the WTO estimates, the 444 hours, are underestimates, but it's unlikely that they would depart wildly from reality, given that these estimates would presumably be reflected in and inform the ACWL's budget and staffing needs. And even if low, it seems like the person hours required for WTO panel disputes and those required for ISDS cases really do differ by an order of magnitude. So this then may raise substantial questions about the financial sustainability of an ACWL type system for ISDS and about its reach in terms of impact. So key questions that came to us as we were looking at these numbers included, how many disputes would an ACWL type ISDS assistance mechanism realistically be able to handle, and at what cost to users and third-party funders? Would it be able to have a meaningful impact on the experiences of a significant number of states? If not, is that okay? Or should the scope of services be reduced and potentially be more focused so as to reach a broader number of beneficiaries? So these issues of possible scope of services and related funding needs are among the cross-cutting issues that apply then to consideration of all potential models. Let's go to the next slide, please. Oops, maybe back one. Sorry, I think I might have missed one. So anyway, so when it was established, the ACWL was predicted to be self-sustaining, operating on income from a donor and member-funded endowment, as well as from user fees. So far, though, that has not materialized. The ACWL needed, for instance, roughly 20 million of additional funds for the time period between 2017 and 2021. User fees for litigation have on average represented about 4% of its annual revenues, and litigation occupies roughly 40 to 60% of its time. So suggestions to also charge for legal opinions have been rejected on the ground that they might unduly deter such requests, impeding the ACWL's mission. So I think what that tells us is an important takeaway is that the issue of funding sustainability, even for an established and well-regarded institution, is not one to gloss over. And this is especially the case given the fact that an ISDS dispute may require 40 to 50 times more hours and corresponding resources than an average WTO dispute. Let's go to the next slide. For some reason, it seems like some of my slides, I'm not sure I see them. But anyway, maybe back. Yeah, well, that's not there. Okay, so anyway, I'll skip over it. But generally, there are several categories of tensions that we also describe in the study and that can arise from different funding models. So those tensions are tensions between donors and beneficiaries, tensions between service providers and beneficiaries, and tensions between donors and service providers. And in the interest of time, I won't go into them, but we tried to highlight how some of those tensions have played out in the context of the ACWL and some of the things that you might see in the governance minutes. It just reflects that these issues of perceived, potential, and actual conflicts have reappeared throughout the research and interviews regarding this and other potential assistance mechanisms. And so key considerations that it should inform discussions are about how a mechanism should be funded and governed. Okay, so there's a lot more to say on these issues, but in the interest of time, let's now move to the issue of investors as assistance mechanisms beneficiaries. It seems like my slides tried to get me there before I was ready. But anyway, so in this context, let's go to the next slide. Yeah, okay. So the issues to consider include whether and to what extent states wish to include investors as beneficiaries for all or some services. If so, which investors? Would it only be for individual investors or SMEs? And if so, for SMEs, then what is meant by an SME? Other sets of threshold issues relate to the nature and scope of concerns that an assistance mechanism is intended to address. Is this, as some might say, an access to justice problem? Or as others argued in the interviews that we held, is the issue of access to ISDS actually something very distinct from the issue of access to justice? So in this sense, it's important to identify the aims of the assistance, the particular challenges that investors are facing abroad, and more narrowly, what challenges SMEs in particular are facing in the context of investor-state disputes. Let's go to the next slide. Starting with this threshold question of what is an SME. Now, this chart illustrates, again, it's in the study, definitions really vary. Quantitative thresholds are frequently used, but criteria differ from country to country. And this can be very impactful. As authors Gibson and Van der Vliet stated in a report, definitions used by some intergovernmental organizations, for instance, would include the manufacturing subsidiaries of both Nestle and Unilever in Ghana, which are clearly not the intended objects of development interventions. So really trying to identify what we mean by SMEs across the world and for this particular purpose is important. So what approach should be taken in this context? We thought a World Bank evaluation of its work to support SMEs was insightful. The evaluation stated that in order for the term SME to be, and I'll quote here, a meaningful category of enterprises, it should be a group of firms that is specifically differentiated from others by the way it experiences particular policy, institutional, or market failures, or the way it benefits the economy or the poor. Once the relevant category is identified, it is possible to determine whether and what type of policy interventions are appropriate and also assess the costs associated with them. So inspired by this approach, we sought to identify particular challenges that may be faced by SMEs, to articulate when those constraints were and were not particularly relevant, and to also highlight some other options for addressing them. So for instance, for many SMEs, the challenge of bringing legal claims is potentially a broader challenge of limited access to finance. This is an issue that transcends access to ISDS, so it might be important to consider whether access to finance for SMEs and improving that is a preferable policy intervention as compared to litigation support for ISDS. Other questions might include then, or other options might include reducing the costs of ISDS cases or channeling disputes into less costly fora. One reason that we flag these issues and alternatives is that as a general matter, even interviewees who in principle support the inclusion of investors as mechanism beneficiaries recognize that doing so will create not insignificant challenges in terms of garnering support for a mechanism that might already face rather large hurdles. So let's go to the next slide and close with this. I mean, I will highlight maybe 5 key takeaways. One is that our consultations reveal that the current concerns around IIAs and ISDS are much broader and more fundamental than only the costs of participation in the system. 2, there are many models that an assistance mechanism could take, and important initiatives are already underway. 3, as policymakers consider the creation or expansion of an assistance mechanism, it'll be important to understand the capacity challenges that potential users are experiencing, and also their preferences in terms of overcoming those challenges, to determine the role that an assistance mechanism should take and what gaps it should fill, and to take into consideration all of the cross-cutting issues that we had identified, such as funding, location, trust and quality, etc. 4, any assistance mechanism should be tailored to the investment law system. Mechanisms that work in other contexts, such as the ACWL, may not be well suited here. And then 5th and finally, it's important to consider this initiative in the broader context of investment law reform. There are a range of options available for addressing concerns about IIAs and ISDS. How does this fit into the mix? What are the advantages and disadvantages of different options and to different stakeholders? And how might those advantages and disadvantages evolve over time? Now, particularly when government resources are scarce, how can we be most strategic regarding demands on those resources and ensure policy coherence across initiatives? So with that, I will stop here.